Our program on immigration and you. I am your immigration attorney, Michael Fulvani, and once again, we are with us, attorney David Nachman, my partner. David, welcome.
Thanks so much, Michael. Always a pleasure.
Thank you. I hope you guys enjoyed the 4th of July weekend. It's still a Sunday today, and continue to your barbecue. And important thing for today is a couple of very important announcements. But first, let us talk about the cutoff dates for the month of July 2014. There's some good news somewhere in that. We'll come to that in a minute. For the family preference categories, it advances by 1 week only to April 1, 2007. The family 2A category, which are the spouses and children under the age of 21 of green card holders, there is no movement, unfortunately. Dates remain the same, May 1, 2012. The family 2B category, which are the unmarried sons and daughters over the age of 21 of green card holders, advances by 4 weeks to May 1, 2007. The family third preference, which are the married sons and daughters of U.S. citizens, advances by 2 weeks to October 15, 2003. And the family fourth preference, which are the brothers and sisters of U.S. citizens, advances only 1 week to December 22nd, 2001. David, before I go to the employment categories, this is one category we have a lot of questions coming all the time from people that are waiting in line for many, many years. And the important question that keep coming is about the CSPA, because the CSPA calculation is done when the visa number becomes available. So people ask, like, if it moves only 1 week every month, it's going to be, 20 years, 25 years, maybe more.
Right.
So, but sometimes it moves faster too.
That's right. Well, Michael, obviously, when we get those requests for information from our clients, they're a little confused about the CSPA calculation and how it works. The CSPA was a law that was put into effect about 10 years ago, and it's a calculation that's performed on the case where what you do is you deduct the amount of time that you have to wait. So what ends up happening is that if an individual ages out, which means that they turn older than 21, then of course what you can do is you can deduct the amount of time that the individual had to wait, and it puts them back before they were 21 years of age. And I know that you're going to be talking a little bit about the new Supreme Court case, so we'll come back to that in a few minutes.
In relation to this, the calculation cannot be made until the visa numbers for that case becomes available.
That's
because
correct.
That's where we'll see he's now today in this month when the visa number became available 24 years and 3 months and he minus so much and then it happens or not.
That's correct. That's exactly right,
That's
Michael.
why I mentioned in the
Right, and what we can do is, as lawyers who handle this type of work on a regular basis, what we can do is we can assist our clients to help them to understand when an individual is becoming 21, how it's going to shake out for their case in the future. But it's not something that's written in stone until such time that the visa numbers actually become available for that particular case.
Now, the employment preference categories, this is for the month of July 2014. The first preference, which are priority workers, are current for all the countries. The second preference, advanced degree holders, are current for most of the countries except India. Now remember, for India, it has been backlogged for a long, long time. Sometimes it's moved up and then went again. The good news this month is the category for India advances by 3 years, 8 months, and 2 weeks to September 1, 2008.
Right.
And before we go to other categories, this is an important point here that we should talk about, because if you remember, in August of 2007, a lot of people applied for I-140 and a 485 together, or 485s, and they got the permission to work and travel. Right. But they've been waiting for that because the visa number retrogression.
Correct.
Now, since that number has moved to 2008, all those cases that were filed in, naturally, they filed in 2007 because the visa number was available at that time. Right? So all those cases that has been pending from August 2007 should be processed now, and God only knows how long they are going to stay here and may go back again So
Exactly.
good advice is
You-
go your lawyers, push them hard, have the immigration service complete your case in maybe in a month or two.
Well, before you push your lawyers hard, check the priority date to make sure that in fact your dates are current. Because if your date's not current, there's no sense pushing the lawyer because
No.
the lawyers.
David, the reason I
Yeah.
said in August 2007, visa number became available
Right,
for all those cases
right.
that are.
And then
that
went
were
into
filed.
retrogression.
Then it retrogression,
Right.
but their priority date of those cases is 2007 or
So-
earlier.
right.
So now we are in 2008. So
Right.
those
Those cases have
immigration
advanced,
service
right.
is supposed to take out and
Exactly.
complete, but sometimes they are slow. And then when
Exactly.
they're slow, while they are waiting, again the numbers go back and the problems.
Exactly, and actually, what probably many of these cases may be seeing upon processing, Michael, and as you know, they recently changed the rules with regard to the medical examinations. So if you submitted medical examinations back when, what ends up happening, unfortunately, is those medical examinations may be expired. So what you may be receiving on those adjustment of status cases from the service centers is requests for evidence, which you've heard us talk about in the past, where those medical examinations will have to be updated. Right. So they just recently came down with a change to the medical examination policies, saying that those policies will only be good for 1 year
2
from
years,
the time,
yeah.
right. 1 year from the time of submission and 1 year from the time of signing. So that's likely to be seen in an RFE.
Now, the employment third preference for most of the countries, there is no movement. Date remains the same, April 1, 2011. Unfortunately for India, there is no movement also. Date remains the same, October 15, 2003. Little movement on the EB3 other workers category for most of the countries except India. Date is the same, April 1, 2011. For India, it advances by 2 weeks only to November 1st, 2003. Now, the fourth preference, which are the special immigrants, religious workers, priests, they are current. And the fifth preference, which is for the investors of $1 million or $500,000, is also current for all the countries, including India. Now, let's go back.
Yeah, but I know, Michael, you wanted to talk about comprehensive immigration
No,
reform.
I want to talk
or-
about the Supreme Court decision.
Oh, okay.
That's very timely.
Okay,
Why?
sure.
Because last week, that you might have watched the program last week, we were talking about the pre-recorded program. So we were saying that Supreme Court is likely to
Make a
probably
determination in that
decision.
case,
And
right.
we were strongly believing that it is going to happen. So I was very happy, very excited.
Right.
Until this decision came, all of a sudden, I have almost tears in my eyes. I say my hundreds of people that are waiting, to whom we have given assurances that this is likely to happen. Likely to happen, I'll just explain in a minute. The Supreme Court, with a majority vote of 5-4. Listen, they are tied, 9 Supreme Court judges in the Supreme Court. And the majority always is considered, wins it. Basically, I have seen a lot of these cases are like 5-4, either way. 5 judges on one side, 4 others. Sometimes there are the different numbers, sometimes they are unanimous also. But this case was 5-4 decision, and I was saying, God, one judge, if they would have changed the mind and got the other side, we will be talking about a different thing in today's program. So the bottom line is that hope, that option is out. So when a child is left out, because the parents got it at that time, the CSPA calculation did not help. And what happens when the parent comes in, father, mother comes in on a green card, leaving the child behind, they come and file an I-130 petition for the child, as long as he remains unmarried. But Immigration Service is giving them a new date, new priority date, because that's why we were hoping that if this Supreme Court decision would have been in our favor, then they would have got the same old date of the parents, but
Correct.
that didn't happen.
Correct.
Now, what is going to happen in the future, God knows, but this no much. We always talked many times about the various other options also, but this option is gone. At some point, David, we were talking about why doesn't President Obama administratively say? Because remember, this case that came to Supreme Court and the lower court, the Superior Court decided in favor. They interpreted this that there is ambiguity and the interpretation should be in favor of these children. It is the government. It's the government that went in appeal to the Supreme Court.
It actually has to do with a legal standard which is referred to as the Chevron case. And in the Chevron case, the holding is that if there is ambiguity in statutes, then the administrative agency is given the authority to decide. And so because the administrative agency is given the authority to decide, the matter of Wang, which is the prior holding, is the one that the administrative agency spoke to. I think the most interesting part of this case, Michael, and I think you would agree with me, is that there was an amicus curiae brief that was submitted by several members of Congress who actually wrote the CSPA. And they were giving their opinion on what they thought the determination should be, and the case went in the opposite direction of the amicus curiae brief. So it was the whole...
Also in the decision, I read the 22 pages decision on this. On this decision, again, they said that the reason that this old priority date cannot be given in the new petition that the parent is filing, because the parties change. The petitioner and the beneficiary, actually, the principal beneficiary, both have changed. In the new petition, the petitioner is the father or the mother who was the beneficiary in the previous case.
Right.
And the petition and the child. So in other words, there is a F2A category.
Right.
So they compare to that where it happens and they continue to remain.
But it has to do with the terminology automatically converts.
The F2A category is for unmarried sons and daughters of
there's automatic conversion. Right.
So why is it automatic conversion? Because while the case is pending, F2A, that is means child is under 21, case is still pending, visa numbers have not become available, the child crosses to 21 and there's no CSPA. In that situation, it automatically changes from F2A to F2B.
Right, automatically
that means the
converts.
children over the age of 21.
Right.
So the Supreme Court distinguished between the two situations.
Right.
He said there it is okay if the same petition continues.
Correct.
Same petitions, same parties.
Correct.
Only the age. So therefore, category changes, petition continues with the same date.
Right.
So this was the reasoning by the Supreme Court.
Right. And actually, Michael, as you know, I just got back from a trip to Boston, where the American Immigration Lawyers Association just recently had their annual convention. And at that convention, we had an opportunity to meet with the people who are litigating that case. So one of our colleagues from the West Coast who actually litigated that case spoke for about, he had a module for about an hour and a half, and he talked about how the case was litigated and what his feelings were. And he also told us that one of the things he's looking into right now is that he's found a procedural methodology to have the government to reconsider the case. So they're actually looking at reconsideration as a possibility in moving forward.
So you mentioned previously about the Chevron case. So it looks like to me that the Supreme Court did not go to the Chevron case because their interpretation was that it is almost clear. There is no ambiguity here. So there is no question of going to the Chevron case and making a decision based upon Chevron.
Well, they're saying that because of the ambiguity, it's determined by the administrative agency. So the administrative agency speaks to it. I think we're just running out of time. So.
Well, a lot of things to talk about. We have to talk about the Comprehensive Immigration Reform Bill, what is going to happen to that. There are many other interesting pieces of information. We are running out of the time. But please keep watching us next programs every Saturday and Sunday, and we'll try to bring the most latest information to you. David, thank you very much for coming.
Thank you so much, Michael.
All of you for watching the program. Thank you very much.